So, what if I told you that a simple satin wedding dress from way back in 1951 holds the key to a really powerful rule that affects pretty much every contract you sign today? Seriously, this is the story of something called the beads rule, and it's a legal idea born from a simple trip to the dry cleaner that has huge, huge implications for all of us. Come on, we've all been there, right? You're faced with this giant wall of tiny text on a screen or some long paper document. You're in a hurry, you trust the person, so you just click agree or you scribble your name. But what happens when what you were told the document said isn't what it actually says? So let's set the scene. Our story starts over 70 years ago, in 1951. A woman named Mrs. Curtis has something very precious she needs cleaned, her satin wedding dress. She takes it down to her local chemical cleaning shop, just expecting, a totally routine service. Now, as she's handing over this beautiful dress, the shop assistant puts a piece of paper on the counter. They call it a receipt and ask for her signature. And this is the moment, right here, where everything starts to change. But here's the thing about Mrs. Curtis. She was paying attention. Instead of just signing without a second thought, she paused, and she asked a completely fair question. Wait, what exactly am I signing for here? The assistant gave her a very specific and what sounded like a pretty harmless explanation. They said, "Oh, it just says we're not responsible for any damage to the delicate beads and sequins on the dress." And, that sounded reasonable to Mrs. Curtis. The beads and sequins are fragile, so it kind of makes sense that the cleaner would want to limit their risk for those specific little things. So, based on that verbal promise, she picked up the pen and she signed the paper. And here's the bait and switch. There's this massive gap between what she was told and what was actually written. The assistant described a super narrow exemption just for the beads, but the clause buried in the fine print, it was incredibly broad. It said the company accepted zero liability for any damage to the dress for any reason at all. You can probably guess what happens next. Disaster strikes. When Mrs. Curtis comes back to get her wedding dress, it's been damaged. There's a brand new stain right on the satin, which has nothing to do with the beads or sequins. And when she complained, the company just pointed to the document she signed and basically said, "Too bad, we're not responsible." But Mrs. Curtis wasn't having it. She knew she'd been misled, and she decided to fight back. So this whole dispute over a single wedding dress gets bigger and bigger, and it ends up in court. It becomes the now famous case of Curtis versus chemical cleaning. The court's logic was just so simple and so powerful. The judge looked at the facts and said, wait a minute, even though Mrs. Curtis signed the paper, her signature was only given because of that misleading explanation. Since the verbal promise didn't match the written contract, the company couldn't just hide behind the fine print. That huge, sweeping clause was declared unenforceable. They were on the hook for the damage. So this whole situation revolves around a key legal idea called an exclusion clause. All that means is it's a part of a contract that tries to say, hey, if something goes wrong, it's not our problem. And you see them absolutely everywhere as companies try to limit their risk. And isn't it funny how a memorable story can actually shape the law? Because of the specific details of this case, those little beads and sequins, the legal principle that came out of it is often nicknamed the beads rule. It's just a simple way to remember that what you say about a contract really matters. Okay, so it's a fascinating story for sure, but you might be thinking, that was 1951. What does a dry cleaning problem have to do with my life today? Well, it turns out the beads rule is probably more relevant now than it has ever been. See, the beads rule isn't just for paper receipts at the cleaners anymore, not at all. It applies directly to our digital world. I'm talking about the terms of service for that new app on your phone, the agreement you scroll through for a rental car, your gym membership contract, even the ticket for a concert. These are all places where these exact same kinds of clauses are hiding in plain sight. So this is the big takeaway from the story of Mrs. Curtis's dress. The law gets it. A signature isn't the be-all and end-all. If you're convinced to sign something based on a misrepresentation, whether that comes from a person, a quick summary on a website, or an FAQ page, that can completely change whether the agreement is actually enforceable. So the next time you're about to tick that little box or sign on that dotted line, just take a second. Remember Mrs. Curtis and the beads rule, and ask yourself, do I really know what I'm agreeing to? Because what's said, or maybe what's not said at all, can matter just as much as what's written down.